Yes, so ilang episodes din tayo, nandun tayo sa family law, nandun tayo sa children law, nandun tayo sa matrimonial finances. Ngayon naman, pupunta tayo sa isa pang area ng law. So, ito ang umpisa ng ating civil litigation series. Ano ba yung civil litigation? What is litigation and what is civil litigation? Litigation, ito yung parating yung naririnig na court action, yung mga threat na I will take you to court, I will sue you, I will ask for a court judgment, county court judgment man siya, or anything higher. So that's civil litigation. The other litigation is criminal litigation. Hindi natin yan pag-uusapan dito dahil I'm not a criminal litigation specialist. Ang aking area of law is mostly civil litigation, which in itself is broad. Ano ba yung mga example niyan? Number one example niyan, kung may nangutang or may pinautang ka at hindi nagbayad, that's contract, breach of contract, or a debt claim, debt. Also, kung ikaw ay may iba pang breaches of contract na hindi nila dineliver, kumbaga yung isang in-order mo o dineliver nila pero defective, that's potentially a litigation dispute na potentially kung isusumo na sila, that will be a court action or a civil litigation. Medical negligence, personal injury, road traffic accident, those are also under civil litigation, especially if it becomes a formal dispute. May pinag-aawayan na kayo. So, pag-iisipin nyo yung mga kaso between tao, company versus individual, individual versus individual, as long as hindi siya family matter, as long as hindi siya children matter, that's mostly civil litigation. Yun siguro yung simplified explanation ko. So, when you're being threatened to be sued sa county court, that is civil litigation. The objective today ng ating session, ng ating class, para mabigyan kayo ng overview, kasi ginawa natin yan sa financial proceedings, ginawa natin yan sa children proceedings, so gagawin din natin yan. Overview muna. Pag sinabing someone will sue you or you wanna sue someone, ano ba talaga ang meaning yan? Diretso ba agad yan sa trial? Diretso ba agad yan sa judgment? Ano ba talaga ang meaning yan? Ano ba ang dadaanan mo? Ano ang may experience mo when you say you will sue someone on a civil matter? Civil lang, not criminal. As I've said, yun ang ating disclaimer, yun lang ang parameters nito. It's all about civil claims. So, nagbabalik ang ating magic whiteboard. Ayan na. So, we prepared here, I prepared here a little, balik natin sa kabila, ayun, para makita. So, ito ang flowchart para makita ang overview kung ano nga ba ang civil litigation. If you are a law student, this could be helpful in understanding. Makikita ba yan? Medyo hindi malinaw ang video. Hopefully, magiging klaro din yan. But I will walk you through it. Don't worry. So, if you want to sue someone dahil hindi nagbayad o nagkabanggaan yung kotse nyo at hindi o may claim ka sa kanya or may binili kang kotse o binili kang malaking equipment at depektibo, that is, as I've said, ito ang proseso. And the first stage of civil litigation is what we call pre-action. As the name suggests, bago pa maging court proceedings, because from there on, claim form, pababa, court proceedings na yan. Diyan ang court proceedings. So lahat nag-uumpisa sa pre-action, hindi ka mag-uumpisa sa court proceedings. So we are under duty, under the civil procedure rules, lawyers are under a duty to engage in pre-action dialogue. Ibig sabihin, susulatan muna namin ng letter before claim. Kailangan malaman ng kabila kung ano ang problema, ano ang concern mo, at kailangan malaman kung ano ang remedy na gusto mo mangyari. In the same way, if you are defending a claim, kailangan malaman mo kung ano bang reklamo ng taong to sa akin, ano ba ang ebidensya niya, ano ba ang gusto niyang mangyari. So that should happen in pre-action. So kailangan mag-engage kayo, hindi lang nagbigay ka ng letter. You do have to engage reasonably. Ibig sabihin, kailangan ma-attempt nyo i-settle kung pwede, kung talagang kung pwedeng ma-settle, kung pwedeng mapag-usapan nyo kung ano man yung inyong legal position. Sasabihin ng abogado, itong position ng kliyente ko, ano ba position ng kliyente mo? So they're gonna try, lawyers will try to have a sort of a debate there para manaro nila. Ano nga ba? Sino nga? Okay, hindi talaga pwede namin i-accept to, pero hindi ito. So that's what we mean by narrowing issues. Kailangan kami mismo ay nag-strength test kami nung kaso para hindi na umabot as much as possible sa court proceedings. So we're gonna have a real good attempt at settling there. Most cases do. Yun talaga, lawyer, I'm not afraid to go all the way, but most of the time, dahil sa cost of a lawyer, time, nakita mo, hindi yan diretso sa trial. Nakita mo, ang daming pagdadaanan bago ka makakuha ng trial at judgment. So there is an advantage to try to settle at pre-action. And that's one of the objectives why meron tayong flowchart. Kasi pag naka-flowchart, makikita mo nga, no, medyo mahaba yung flow. Madaming mga boxes kailangan daanan. So if we can't settle, we settle here. We send a letter before action. Minsan nagme-mediation kami dyan. Minsan, we would even exchange evidence. We would try as much as we can to be able to figure out kung ano yung case ng isa't isa. So hindi yan taguan ng kaso, taguan ng ebidensya. You're gonna have to try. Dahil kung hindi mo gagawin yan ng maayos, you can potentially be penalized later on sa trial at sa judgment. So pag unreasonable ka dyan, makikita mo na magkakaroon ng epekto dyan. So the case actually doesn't start sa court, it starts here. It starts dito pa lang pre-action. Pwede nang mo-audit ng court ang conduct ng mga partido. Some instances, hindi talaga nagsisettle. Kailangan talaga ng assistance ng korte. So how do you start a court proceedings? Sabihin na naririnig, I will sue you. I'm threatening to start court proceedings. Ano ba talaga ang nangyayari sa umpisa? So you have to file a claim form with particulars of claims. So hindi lang claim form yan. Actually, may particulars of claim. POC. Lagyan lang natin POC para. So claim form, short summary. Nakalagay doon kung ano yung claim mo, breach of contract ba yan, debt claim ba yan, mutang ba yan na hindi binayaran, ano ba yung interest, ano yung outstanding, ano relationship, contractual relationship nyo, whether bangko ka ba o nagpautang ka lang, and so on and so forth. The particulars of claim, as the name suggests, mas detalyado. So, umpisa pa lang, alam na kung ano yung hinihingi, alam na kung ano yung claim. And lawyers would know, if you are a law student, may mga format yan. Kailangan may specific na impormasyon yan for it to be a proper claim form and a proper particulars of claim. After that, you will get a chance to defend. May acknowledgement muna. I didn't put it there, but this is overview. So acknowledgement of service, 14 days. You get an extra 14 days to defend kung gusto mo mag-defend. But for the purposes of today, you can just see, look, you have to acknowledge and you have to defend. So lagay natin yung AOS para baka may magsabi, hindi naman ano yan. AOS is acknowledgement of service. You're just acknowledging na natanggap mo yung form kung ikaw yung defendant, and you have to file a defense. After that, naku, may questionnaire. Ano yung allocation questionnaire na yan? You will be asked by the court. So, makikita na nila, kita nilang claim form, makikita nila yung defense or counterclaim. Kung ikaw may counterclaim, dito man naman ilalagay. Lagay natin dyan. Counterclaim. So, as early as possible, alam na natin kung magkano at ano ang claim ng bawat isa at kung may counterclaim sila. Klaro ang value ng claim as early as possible. You can't go at trial at sasabihin mo, naku, ay na may nakalimutan akong 100,000. You can't do that. Now, pag nakita na ng korte yung value ng claim as well as yung complexity ng claim nyo, they will send you an allocation questionnaire para kumuha ng further information. Ilan ba expert? Kailangan nyo ba ng expert? Kailangan nyo ba ng ilang witnesses ba ang kailangan nyo? So you can see as early as possible tinatanong yan. Kasi bibigyan kayo ng track allocation. It doesn't necessarily mean na fast track ay mas mabilis. These tracks are just indicative ng value ng claim. So small claims, you've heard me say this before, these are 10K below, 10,000 pounds below. So, pag small claims ka, onti lang yung mga stages mo. Kasi mas simple. You know, the court is saying that these should be simpler. These should be fairly straightforward. And normally, pag small claims ka, no one gets their cost back, legal cost back. So, remember that. Just remember that kung kayo ay you're engaging in litigation. That's the reason why it's well simpler siya. So you might just have a date to disclose documents and file witness statements, and you will just have a trial date in due course. So quite simple, very straightforward. However, if you are fast track, which is not fast at all, let's be very clear about that. It's a strange thing why they call it a fast track. That's 10K above to 25K. That's fast track. Ay mas marami kang dadaanan na stages and almost the same as multi-track, 25K plus. Depende na yan sa complexity ng case. Depende na yan sa kung ano ang kailangan ng kaso. But first, you're gonna have a CCMCC. What is a CCMCC? That is what we call a cost and case management conference. So yan ang I think CCMCC, cost and case management conference. This could be remote, telephone lang, pwedeng face-to-face, pwedeng video. But what it is not, hindi yan trial. Minsan, sasabihin ng client, oh, may hearing tayo. Red na naman kasi hearing, di ba? May hearing tayo. Oh, ang bilis naman. Trial na ba yan? No, that's what we call housekeeping. Dahil mostly mataas yung value ng case or above 25K or between the fast track and 25, kailangan tingnan ng korte on a closer look, hindi lang allocation questionnaire, kung ano ba talaga ang kailangan ng case na to. If it's a medical negligence case or personal injury case, kailangan nyo ba ng expert? At sino ang expert na kukunin nyo? Ano ang mga directions? Ang tawag namin dyan, directions. Not left or right, just court directions. Meaning utos, order or directions. Deadlines, if you want another synonym to it. So, magbibigay ng korte ng order kung ano ang mangyayari sa case. Depende kung ano yung kailangan ng kaso. Sometimes if it's a builder case, so sabi mo, inutusan ko yung builder na to, gawan ako ng bahay, pero hindi naman stable yung bahay. So you may need a surveyor and another expert to do that. So dito aalamin yan. Parang may project management. Yun ang idea. The court will case management ang term namin dito. The court will case manage as early as possible para mabigyan ng ruta, ng mapa kung ano ang mangyayari sa kaso. Hindi lahat ng hindi lahat ng case kailangan ng expert's report. Minsan, kailangan ng mas maraming expert's report din. So, one example na mangyayari after a case management conference is disclosure. Sa Amerika, America, tawag nila discovery. I don't know kung anong tawag nila sa Pilipinas, but that is disclosure. So, kailangan ibigay ng isa't isa, ng isang partido sa kabilang partido, both parties would need to provide all the documents, favorable man sa kanila o hindi, which are in their possession. So, let me repeat that. All documents in their possession, electronic o hard copy man yan, they have to provide it to the other side. So they have to provide the list in the first instance, how it goes. They have to provide the list and sasabihin ng kabila, ay gusto ko yan, kasi, yan nakita ko na yan, hindi ko na kailangan yan, but the rest hindi ko pa nakikita. I have to get that. The idea is that show hands. Kailangan mong ilagay, lay your cards on the table, andyan ang lahat ng ebidensya, and you can see, maaga, hindi shortly before the trial, maaga. The reason being is that as you go along litigation, pataas ng pataas ang legal cost mo. So, kailangan malaman mo as early as possible ang merits ng kaso mo so that if it is right to settle, then you settle as early as possible as well. So, disclosures, witness statements, sometimes people think that witnesses just turn up at trial. No, witnesses actually provide written witness statements months before at doon lang sila i-cross-examine. Hindi ko namin sila pwede cross-examine sa statement na hindi naman nila ibinigay. They can't potentially be introducing new evidence to the court. Kailangan malaman ang extent lang itong nakalagay sa witness statement nila, which should be relevant lang sa kaso. So, as early as possible, although na-remember nyo, tinanong na kanina ilan ba witnesses nyo. So, talagang minamanage. There's an active case management ang korte ng UK. So, witnesses will give their statements, and then only then, experts. So, andyan na yung mga documents. The idea is, prepared na yung mga documents bago tayo kumuha ng expert. So, normally, joint expert yan. Whatever the case needs, maybe kung isang road traffic accident, an orthopedic consultant, kung isang construction dispute, you need a building surveyor or a building expert, and the court would have to permit that evidence. Hindi ka pwede na ikaw lang on your own initiative kumuha ka ng expert. Kailangan, in order for that expert report to be admitted to the court, kailangan may blessing ng court, may ordered by CCMCC. So, kailangan dito ordered yan ng court. Then, may hearing na naman, hindi pa rin yan trial. We call it a pre-trial review. So, bago kayo pumunta ng trial, kailangan tingnan, check ng korte kung ready na ba lahat. Ready na disclosure, ready na yung witness statements, ready na yung report before ang final na trial or final hearing as we call it. Kung hindi pa ready, magbibigay ng other directions ang korte para maging trial ready ang isang kaso. So that may be may nawawalang disclosure or kailangan pa ng isang expert. Nakita na hindi naman enough yung sinabi ng expert na yun eh. So kailangan hindi pa ready tong kaso na to. Hindi pa kompleto ang ebidensya natin. So the court will manage that. So hindi pa yan. So isipin mo, naku, eto na naman, hearing na naman. Only if trial ready na, andyan na lahat, only then will we go to a full hearing, a full-on trial where there will be opening submissions, there will be cross-examination ng mga witnesses na nagbigay ng ebidensya, there will be may mga bundle ng mga ebidensya ng disclosure for final trial. You know, that will also be subject to legal submissions. Most of the time, hindi naman most of the time, but may mga instances na hindi mo makukuha yung judgment on the day. Actually, kadalasan in reality. Dahil kailangan pa mag-isip ng judge or hindi enough yung time na nabigay sa isang kaso. So, minsan, maghihintay ka ng weeks, depende sa availability nila. But minsan, man, I had instances on higher courts dahil I think mas busy sila o mas complicated yung legal submissions. It tends to be longer. I think it's also because of that particular area of law. It tends to be, it was planning law, mas mahaba yung hinintay namin compared to county court. Siguro naghintay lang kami ng 2 weeks. But may instances, akala mo tapos na, malalaman ko na ang hatol. Sometimes hindi dahil judges would have to write their judgment. Hindi lang yung sasabihin, oh, nanalo ka. No, there should be what we call a handing down of judgment. Yun ang term. At bibigay ng judge ang reasons bakit ganoon ang kanyang judgment. Either, for example, dun sa sinabi natin na case, ang kanyang judgment, naniniwala siya dun sa partido na inutangan. And the judge would say, well, I believe that the contract formed on this date, verbally bound or written, and the claimant was promised by the defendant to be paid X amount per month, etc., etc., and the defendant failed, and so the defendant must now pay the total outstanding sum of, say for example, £15,000 plus the claimant's legal costs. So the judge is giving reasons for the judgment para klaro bakit, ano dun sa ebidensya. For example, ang kanyang sa tingin niya very pertinent or important dun sa judgment. So you will listen to, you will learn from the judgment kung saan kinuha ng judge, ano yung basis ng judgment ng korte, dahil naniwala ba sila dun sa witness statement, naniwala ba sila sa WhatsApp na conversation. That's something, if you're a law student, ito na yung nababasa ninyo na judgment, yun ang hinahanap namin, na pagkatapos ng napakahaba naming preparation at stages ng litigation, we're looking at which part of this case, which part of the evidence, which part of these documents did the judge see as having higher weight. Yun ang term namin. Did the judge place higher weight on para makonvince sila na nanalo itong partido na to. So that's the reason why it's very important to hear that judgment. And as an additional tip or advice, we can actually, kung i-appeal mo yung isang judgment ng court, you can apply for a transcript. So pag i-hand down na yung judgment na yan, may transcript, may recording yan lahat, and you can apply for a copy of the transcript, yung typed up version ng judgment, so that you can read as clearly and as detailed, that you can read the detailed set out of the judgment and kung ano yung ebidensya that the judge had placed heavy weight on. The reason for this, as I've said, the reason bakit in-explain natin to, although we are trying to make law as user-friendly as possible, is para mabigyan natin ng overview ang ating mga kababayan na hindi depende yan sa value. Although kahit maliit na value, meron pa ring assignment, meron pa ring pagdadaanan, hindi diretso sa trial. At kailangan mong i-attempt na mag-settle, mag-usap sa pre-action. May mga documentary requirements, may mga deadlines, yun ang tatandaan, deadlines. At pag na-miss mo yung deadline, strike out, we call it strike out, dismiss ang kaso mo, matatanggal ka, strike out by default. May mga hearings na hindi trial, so hindi agad yan full trial. It should be actively managed. Kailangan alam natin kung ano yung kailangan natin as early as possible, dahil you can't just pull a witness, hinaya mo lang yung best friend mo magbigay ng witness at trial. That doesn't work. And most importantly is makikita mo na that's the reason why people say, naku, mahal mag-sue, mahal mag-civil litigation. It's an expensive process. Bakit ganun kakomplikado? Bakit ang taas ng cost? The reason for that is all of these stages. Mga court directions that we need to follow, documents that we need to submit. That's also the reason why us lawyers do tell the client at each stage of litigation, and nakalagay yan sa civil procedure rules, nakalagay yan sa court direction, that you must consider settlement at each stage of litigation. Dahil ito, hindi sure yan. There's always a risk in trial. Kita mo, could be expensive, at yung judgment potentially hindi sa'yo. So you have to think even here kung paano masusolba yung problema without going through all of this cost, all of this effort, all of this risk, but still you can get to what we call a commercially sound solution. But as I've said, that's stages of litigation in a fairly general view. Please kumuha po kayo ng specific advice para sa kaso nyo, dahil depende yan sa complexity ng case, depende sa simplicity ng case as well, and there are cases where minsan nakakadalawang PTR kasi hindi pa na-solve yung directions, may mga kulang, minsan may problema sa disclosure, may issue about experts, so it's not a straightforward or hindi yan applicable yung template na yan sa lahat ng kaso. But I hope na nakatulong po. I hope nakadagdag ng kaalaman. I hope nakadagdag ng mga trivia nyo about civil law in the UK. And I hope na maaalala nyo yung mga main takeaways natin, which is kailangan pag-isipan mag-settle as early as possible. Not at all cost, not kung but kailangan pag-isipan ng malalim at husto. May mga deadlines, maraming stages ng litigation, hindi agad pupunta sa trial, and it can be expensive, it can be costly, hindi lang sa pera but time, energy, resources. And that's the reason why, hindi lang pre-action, but at each stage of litigation, kailangan hanapan natin ng solusyon without going through all of those risks and without going through all of those time, resources, and energy.